Good morning, gentlemen.
Good morning, Your Honors.
Good morning, Your Honors.
We are ready when you are ready to proceed. Mr. Is it Safriat?
Mr. Safrit, Your Honor.
Safrit, okay. Sorry.
Great.
Go ahead.
Thank you. May it please the court. Kent Safrit with Hopping Green and Sam's on behalf of the appellates Siesta Key Association of Sarasota, Inc. and David Patton. Your Honors, the sole issue before the court is whether the circuit court erred in interpreting the permit exception found in section 403-412 subsection 2E to bar a cause of action because the Department of Environmental Protection issued a joint coastal permit pursuant to state statutes when appellant's cause of action under 403-412 is premised entirely on the city's failure to obtain a permit from the Sarasota County Water and Navigational Control Authority pursuant to Sarasota County Code section 54-653.
Can I ask you a question on that right out of the box? When I look at 54-651, the purpose of the article, which I assume is 54, seems to deal with construction of structures. And if that's the purpose of Article 54, why would I need a permit from Sarasota County when I am not doing any sort of construction? I'm doing dredging on navigable waters owned by the state of Florida.
Well, under 651, Your Honor, the purpose is shoreline protection structures, and a beach nourishment project, such as the one that is occurring here, is a part of a shore protection structure. And the fact that it dredges 1.3 million cubic yards of sand and places on a beach, along with two growings. It places two growings, lengths of 175 feet and 345 feet into Sarasota Bay, or into the Gulf of Mexico, Your Honor. And with respect to 653, even notwithstanding the purpose category of 651, 653 clearly states when a permit is needed with respect to any kind of alteration of the area. And there it says, no work shall be performed having the effect of altering any jurisdictional areas without first obtaining a WNCA permit from the authority or administrator. You look at the definitions of altering, Your Honor, and that includes the dredging, not merely the construction of a dock.
You don't argue that the Corps of Engineers needs a county permit?
No, we have not made that argument in this case, Your Honor.
You probably couldn't.
Probably right, Your Honor.
Okay.
They don't need a WNCA permit from the county.
I understood.
Right. Okay. So with respect to the local requirement, altering means dredging, filling, placing, building, and it goes on for a lengthy definition of what altering includes here. And there's no doubt the removal of 1.3 cubic yards, the destruction of 1.68 acres of seagrass, and the construction of these two growings constitutes altering of a jurisdictional area within the jurisdiction of Sarasota County.
I'm correct that this pass has never been dredged before. Is that right?
That is correct. This pass has never been dredged before. It's not a maintenance situation where a dredge has been a pass has been dredged and is routinely maintained.
Okay.
Okay. With respect to the legal issue in this case, Your Honor, it's first important, I believe, to understand the cause of action provided in 403-412 2A2 so that we can understand the permit exception to that. And if you look at the cause of action under 403-412 2A2, it provides that a citizen of the state may maintain an action for injunctive relief against, among other entities in the city in this case, and I quote, from violating any laws, rules, or regulations for the protection of air, water, and other natural resources of the state. In our case, the appellate's basis for their cause of action under 403-412 is section 54-653 of the code, which I just referenced. And with respect to that portion of the code, that is clearly a law for the protection of the air, water, and other natural resources of the state. And in this case, the circuit court did not determine if a WNCA permit by the local code is required, nor did it assess whether the city possessed one. Rather, the the circuit court misconstrued the permit exception in 403-412-2E to bar the appellate's claim based on the issuance of a colliery joint coastal permit by the state. And the permit exception language is found again in 2E of 403-412. And it states that no action pursuant to this section may be maintained if, naming numerous parties, the city in this case, is acting or conducting operations pursuant to currently valid permit or certificate covering such operations.
Right there. Let me stop you there, if I may. That language seems to suggest that there is in place an already issued permit or certificate.
That's correct, covering the operations that form the basis of the cause of action.
The existing permit comes from the state.
One permit, yes, Your Honor.
So I'm wondering why, how you get to the point where basically this statute anticipates to be issued permits under Chapter 53, for example.
Yeah, it's this subsection E, Your Honor. It's a safe haven. It's a permit exception. So what the cause of action says is if there's a law out there for the protection of natural resources and somebody's violating it, you have a cause of action. But if they have a permit issued by the appropriate authority such that it's not a violation of that specific law you allege, then they have a safe haven. If they don't have a permit based on that alleged law that is for the protection of natural resources, then they don't have a protection. And in short, Your Honor, in this case, the joint coastal permit was issued by the Department of Environmental Protection. And it's in essence 3 permits. It's a coastal construction permit under Chapter 161. It's a permit under Chapter 373. And it's a permit or an authorization for state lands under 253. So for those chapters, 161, 253, 373, we allege no violation in our complaint. We can't. They've got a permit that covers that. So they're safe from any 403-412 claim based on violations of 161.
See, I'm not wedded to this, but I'm wondering if one can read it as maybe there's some other remedy against the city, but it seems once I get my DEP permit, that is the currently valid permit that eliminates the private cause of action.
But it eliminates the private cause of action based on 161, 253, or 373, Your Honor. Right. It doesn't eliminate a private cause of action based on violation of the county code. If the city were to have a WNCA permit, then it would eliminate our private cause of action based on the county code in this instance. And that's the fallacy of the error in the court's ruling. These projects require multiple permits. It's not just one permit. And that's what subsection E, the permit exception, recognizes.
Well, if that's the case, that there are multiple permits, including one from the county, why is the county not here?
That's a good question, Your Honor. We didn't sue the county to bring them into this case, nor did we have to. And, the county and its commissioners and politicians, they make decisions for, any number of reasons. So I cannot impute to them why they are or they're not here. All I can say is I believe the WNCA requires a permit for this activity by the city, and there's a private cause of action under subsection 2 of 403-412 that requires the city or allows us to get an injunction and join in the city and requiring them to obtain that.
That raises another question for me. Is it the case that all the activity, that the beach renourishment is going to be on not on Siesta Key, the sand's not going to go there, but the dredging is taking place on sovereign submerged land, correct?
That is correct, Your Honor.
So I'm going to tell the city that they have to go to the county to get a permit to tell the sovereign, the state of Florida, what they can do with their submerged land.
That's correct, Your Honor, because the county has jurisdiction over that submerged lands, both by a special law that we cited in our brief. I believe it's in 1950. 3, Laws of Florida 57-1853, and there's always concurrent jurisdiction based on local governments and state governments when it comes to regulation of activities and land use. And Your Honor, the case that we pointed out in our brief, GLA Associates versus City of Boca Raton, is directly on point. And in that case, the GLA received a coastal construction permit from DEP, very similar to the one here under Chapter 161. GLA started to begin work, rehabilitate a dune and a dune walkover, and the city brought an enforcement action or brought a notice of violation for that. And in that permit, and specifically in that permit to GLA, DEP said, and I quote, GLA is required to, quote, obtain any applicable license or permits which may be required by federal, state, county, or municipal law. And we have a permit in the JCP in this case that's almost identical to that. General condition number 3. So DEP recognizes and has forever that just because you get a JCP from us doesn't give you all the authority and approval you need, because you may need federal permits, you may need local permits, and the WCNA is an example of that. And in that GLA case, Your Honor, the city denied the permit to GLA, and so DEP then revoked the coastal construction permit under 161. GLA argued on appeal, which is a similar argument I think that Your Honor is making, is that Chapter 161 preempts the City of Boca Raton's code requirements to get a permit. And that court found absolutely not. 161 does not preempt local ordinances. And the court concluded that the city's ordinance is more strict in that it prohibits excavation of the dune where the state would apparently permit it. Therefore, the statute neither preempts the ordinance nor is in conflict with it. And that's the same in this case. And specifically, DEP in that case, Your Honor, filed an amicus brief saying we've always taken position Chapter 161 never preempts local ordinances to that effect.
The cases that you cite also deal with submerged lands only, or with construction of other edifices in an area?
It did not deal with submerged lands to my knowledge. It dealt with just a coastal construction permit along the beach, along the area. But with respect to, again, submerged lands, there is no preemption in Chapter 253 that says local governments are preempted from regulating sovereign submerged lands. And I would submit to you that the state of Florida, through the Chapter 57-1853, which is a special local law, has delegated to the county to regulate sovereign submerged lands with respect to dredging and filling. And then there's a case that we cite in our brief too, 2nd DCA, County of Sarasota versus Neville, which held that the Water and Control Authority here in Sarasota County has that authority to regulate sovereign submerged lands. And so there is no
Does the Corps of Engineers really need the city in this? Suppose the Corps of Engineers says we're going to do the whole dredging, we're going to do the whole renourishment. It seems to me they could.
That might be the case, Your Honor. I know there's a lot of other federal laws that regulate what they do and how they do it, but they do need the city in this case because the city is a local sponsor, and I believe the city was responsible for obtaining all of the local permits for this because it's a joint project. It's not one or the other. And if the court had done that, we wouldn't be here, Your Honor. And so with respect to the GLA case, and very similar to it, here in the same case, the WNCA, the county code, is more strict than DEP's rules. For example, I'll give you one example, is seagrass mitigation. In the Sarasota County Code, it requires the mitigation occur within Sarasota County. And the 1.68 acres of the seagrass is being destroyed under the county code, that must be mitigated in Sarasota County. The DEP permit under Chapter 161-373 allowed mitigation to occur almost 15 miles away in Perico Preserve in Manatee County. And so that's an instance, just like the GLA case, where the county ordinance is more strict than the state ordinance. And the city did not have to comply with the county code ordinance where that mitigation would require or be required to occur in Sarasota County rather than Manatee. So again, the permit exception under 4-2-E it only applies if you have the proper permit. And that subsection, if you look at it too, Your Honor, says issued by the appropriate governmental entities or agencies. It acknowledges there's going to be multiple permits for a project. You got to have the permit for and from the specific agency in charge with enforcing the law that that's the basis of the allegation. And again, there's no allegation in our complaint that there's a violation of 161, 253, or 373. The sole allegation is there's been a violation of the county code. And to protect themselves from that and invoke this permit exception, they have to have a WNCNA permit. The JCP protects them from a 403, 412 case based on those 3 state statutes. And
Excuse me for interrupting you. If you want to save some rebuttal time, you are a little bit over 15 minutes. You can use your time as you wish, but I just want to give you the heads up.
No, thank you, Your Honor. And with that, we would obviously ask the court to reverse the circuit court in this case, and I will reserve the rest of my time.
Thank you, sir. Mr. Hennessy.
Your Honor, this is Mr. Heron.
Heron, I'm sorry.
Sarasota. Mr. Hennessy and I have agreed to split our time evenly, 10 minutes each, but the city of Sarasota would go first and,
okay.
And address the issue of the applicability of the exemption 403, 412 to E Florida statute.
I'll let you know when you hit 10 minutes.
Thank you. If it pleases the court. As the appellant asserts, they are alleging the trial court erred in ruling that the appellant's cause of action is barred by 403, 412 to E Florida statutes. We obviously disagree, and for the following reasons. Briefly, by way of background, I think it's important to point out some additional facts for the court to consider that are, in fact, part of the record before it. The appellant filed a 2-count complaint against the city of Sarasota on its 3rd attempt to state a cause of action. Throughout the proceedings and throughout its complaints, count 1 essentially stayed the same, which was seeking injunctive relief against the city of Sarasota pursuant to section 403, 412 2A, alleging that the city was in violation of laws, rules, and regulations intended for the protection of the environment. Specifically, appellant alleged the city was in violation of section 403, 412 because the city failed to obtain the approval or permit from the Sarasota County Water Navigation Control Authority for this project under section 54, 653, 4A, as alleged by Mr. Safrit. The trial court twice dismissed count 1 of the appellant's complaint, its complaint and its amended complaint, and then on its second, actually on its 3rd filing, the appellant filed added a second claim for mandamus relief to compel the city to obtain this permit that that appellants allege is required under the city's comprehensive plan, the county's comprehensive plan, and in particular section 54, 653, 4A of the Sarasota County Code. In fact, the appellant's prayer for relief with respect to count 2 specifically requested the trial court to compel the city to comply with section 54, 653, 4A of the Sarasota County Code by obtaining a permit. To Judge LaRosa, your previous comments. The trial court rejected this argument and determining it could not require the city to submit an application for this permit, that it was outside the scope of the proceedings and not within the court's authority to do so. The appellant has not sought this court's review of that portion of the order of dismissal with prejudice, and therefore it's binding on all the parties. And it's important for this reason, because if the city is under no legal obligation to obtain a permit for under section 54, 653, 4A of the county code, how can it be in violation of that section of the code? The court has said, you don't have to obtain this permit in order for this project to proceed. So we believe that the court was correct in that analysis, and you cannot disassociate those two components, the count 1 and count 2 and the complaint, that both were dismissed with prejudice by the trial court. as pointed out by the court in its questioning of appellant, this project has been approved and authorized by a joint coastal permit issued by FDP, and it doesn't require the city to obtain this permit from the Sarasota County Water Navigation Control
The
Board.
JCP does contemplate that other permits could possibly be required.
That is correct. But in this case, the trial court determined that the specific permit on which the appellant's cause of action under 403-412 does not require the city to obtain a permit from the Sarasota County Water Navigation Control Authority, that it doesn't apply. So the trial court correctly determined that that 403-412-2E, the exemption language, precludes the appellant's cause of action. And I think it's important to point out that there's actually a case cited by the appellant in their briefs, which is the Florida Wildlife Federation versus State Department of Environmental Regulation, where the appellate court in that case said that in order for a cause of action to lie under 403-412, the question raised must be real and not merely theoretical. Here, the trial court has found that this is a theoretical issue, that there's no need for the city to obtain a permit under 403-412 or under the Sarasota County Code for this project to move forward.
Help me out, Mr. Herron. Mr. Suffert relies heavily on a GLA case. What's your take on that?
Yes, Your Honor, I appreciate you that they do rely almost exclusively on the GLA case, and really for the proposition that compliance with local ordinance is required, notwithstanding the DEP's issuance, the JCP. However, the GLA is distinguishable on a number of bases that preclude its application of the facts and law that the trial court applied here. Specifically, the cause of action that was under attack in the GLA case was actually under Chapter 161, not 403-412, the cause of action that's being brought and being challenged here. They're not the same statutes, and it would be inappropriate, I think, for this court to impute the ruling in GLA pursuant to a discrete section of Chapter 161 to a completely different statutory scheme under Chapter 403. Furthermore, unlike in 403-412 and the statutory language regulating activity in sovereign submerged lands in Chapter 161, the statutory provision under attack in GLA specifically recognize local ordinances and their applicability. There's no such similar language in 403-412 anywhere. The language in 403-412 is law, rule, and regulation. And this court in Snow versus Rudin-McCluskey, another case cited by appellants, very specifically distinguished and explained the distinction between law, rule, regulation, and an ordinance. A law is enacted by the legislative branch, according to this court, whereas an ordinance, although similar to statutory law, are enacted by local government body. They are similar but not the same. In fact, this court went on to say that each of these terms, statute, ordinance, rule, and regulation, their meanings are well known to the legislature. So if in fact the court had wanted to include ordinances as a basis for a cause of action under 403-412, as opposed to simply a law, rule, or regulation, it would have put in the statute law, rule, regulation, or ordinance. It did not do so. And based upon this court's own prior precedent, they're not the same. And it would be inappropriate for this court to impute to that language in 403-412 the extension of it to also include ordinances as suggested by appellants in this case. Furthermore, as Judge Black indicated, construction activity at issue in GLA was on uplands, on private property, not state submerged lands, as is the case with the JCP and the issue before this court. Furthermore, at the appellant's brief at pages 10 and 12, they specifically state they state the cause of action is not premised upon violations of Chapter 161, 253, or 373 Florida statutes. Therefore, their reliance upon GLA, which is a case interpreting Chapter 161, simply doesn't apply here. So to the extent that GLA only addressed the narrow interpretation of a statute the appellants readily admit doesn't apply here, their reliance is inappropriate, in our opinion. Furthermore, at no point in any of the administrative or court proceedings that have taken place over the last 2.5, close to 3 years in this case, has Sarasota County ever objected to the project, indicated that a permit is required, or otherwise said, you know, there's a problem here. And in fact, on numerous occasions, the appellants have asked the county to take action with regard to this project, and the county has said no. And in fact, very recently, they asked for the county to issue a stop work order for this project, which is ongoing. And the county demurred and said no, because their position is that there is no requirement under I'm sorry.
That's probably just reminding you that you're near your 10 minutes.
Yes, that my 10 minutes are up. That's correct. So in summary, we believe that the cause of action and the argument set forth by the appellants in this case don't apply here. And we think that it's appropriate for this court to uphold the decision of the court dismissing their cause of action with prejudice and such other relief as this court deems appropriate, including the award of attorney's fees as the prevailing party. And I will at this point cede the argument to my co-counsel, Mr. Hennessy.
Thank you, Mr. Herron. Mr. Hennessy.
Thank you, Your Honors. Kevin Hennessy, Lewis, Lawman, and Walker for Appellee Lido Key Residents Association. I'll be arguing the second issue on appeal dealing with whether a cause of action was stated under 403-412. It's the appellee's position that the complaint was properly dismissed for failing to state a cause of action for numerous reasons. While the appellants would like to limit this appeal to consideration of only the grounds ruled on by the trial court, as an appellate court sitting de novo, any appropriate legal basis for the decision is grounds to affirm. And we have cited the case of Dade County versus radio station WKBA for that point. And I will quote from the Dade County case. It is elementary that the theories or reasons assigned by the lower court as its basis for the order or judgment appealed from, although sometimes helpful, are not in any way controlling on appeal. And the appellate court will make its own determination as to the correctness of the decision of the lower court, regardless of the reasons or theories assigned therefore. Stated another way, if the trial court reaches the right result, but for the wrong reasons, it will be upheld if there is any basis which would support the judgment in the record. Now, we believe that the trial court found correctly for correct reasons, but that there were additional correct reasons that I will go into as to why the dismissal with prejudice is appropriate. I will also note that the cases cited by appellants are not analogous. They either dealt with issues where they were not raised in the trial court, or factual determinations were required by the trial court, and that's why the Tipsy-Coachman doctrine was not applied. That's not the case here. So first ground, that the complaint fails to allege and cannot allege that proper notice was given under section 403-412 2C to Sarasota County. It's an important distinction. Sarasota County is the entity that purportedly is enforcing section 54-653 parens 4 parens A of the Sarasota County Code. In order to properly allege notice to the county, it was incumbent on the appellants to allege three things. Number one, that a verified complaint was served on the county. Number two, that 30 days was given to the county to act. And number three, that the county failed to take appropriate action. None of these allegations were contained in any of the complaints that were dismissed, despite the court's requirement or allowance for amendment. We cited to the case of Fernandez versus Santa Rosa County, which we feel is on all fours with this case, in the sense that Fernandez dealt with a 403-412 complaint and specifically outlined the three requirements of pleading that I've just recited. And in that case, the court held that plaintiffs failed to allege compliance with the three conditions precedent. Therefore, the trial court properly dismissed the complaints. That Fernandez case was very similar to this case in that it dismissed the complaint the first time for failure to allege the allegations. The second time, when those allegations again were not alleged, it dismissed with prejudice, similar to what happened in the case below. Appellant argues that notice was pled, but contrary to its reply brief allegation, when you look at paragraph 36 of the second amended verified complaint, they state that service of the complaint on the city 30 days before filing. That's all they allege. And as we indicated, it's not service on the city that's important here. It's service on the entity that has the ability to correct the deficiency, which would be the county. The county has the ability to go and require a permit or make the statement that it doesn't require a permit. And that's frankly why we think that they never served the county, is because they didn't want that response coming from the county. That citation is on page 1200 of the record on appeal. It's allegation 36. Fernandez goes on to clearly state that these notice requirements must be strictly met, and they were not met in this case, and therefore motion dismissal on that grounds was appropriate. Another appropriate grounds for dismissal is because 54-6534A is not a law, rule, or regulation enforceable by 403-412-2A. I believe Mr. Herron spoke a little bit to this, so I'll not reiterate. But frankly, it does not, 403-412 does not use the term ordinance. And this was quoted by Mr. Safried earlier. It says, any person, natural or corporate or governmental agency or authority to enjoin such persons, agencies, or authorities from violating any laws, rules, or regulations for the protection of the air, water, and other natural resources. It doesn't say ordinance, and we would say that the plain meaning of law, rules, or regulation doesn't contemplate ordinance. And we would point to subsection 9A of 403-412, where it's clear that the legislature understands the distinction between an ordinance and a law, and a local government and a state agency, where it states a local government, regulation, ordinance, code, rule, comprehensive plan, charter, or any other provision of law may not recognize or grant any legal rights to a plant, an animal, a body of water, or any other part of the natural environment that is not a person or political subdivision as defined in section 10.01 parens 8. So clearly the legislature in drafting 403-412 was well aware of the distinction between a law, rule, and regulation of a state agency and an ordinance of a local government. Your Honors, we also cited the case, as indicated, appellants cited Snow versus Rudin McCluskey, where it was determined that law, rule, or regulation didn't include an ordinance, did not include the rules of the Florida bar. But instructive in that case is that dealt with a whistleblower law of state whistleblower law for Florida, 448.101, and the definition of laws, rules, and regulations in that statute includes ordinances. So once again, it can be presumed that the legislature understands the language that it's using, and it could have added ordinance here in 403-412, and it did not. We further cited Evans Rowing Club versus City of Jacksonville. In that case, the court distinguished state agency regulations from local government ordinances in determining that the constitutional amendment to Article 5, Section 21 does not apply to local government land use ordinances. We think that's also persuasive. The only case cited by the appellant with regard to this is the Save Our Bay versus Hillsborough County pollution control case. Now, that case clearly concerned a county delegated the enforcement of state laws. And so it is inapplicable or distinguishable from the situation here. Appellant also cited the Orange County Audubon Society versus Hold, but frankly, from that opinion, you don't know if the county was being sued under subsection 2A1 for failing to enforce a state law, or under subsection 2A2 for the county, in that case, violating a state law itself. So it's just, but the importance of both cases cited by the appellants is that both of them deal with standing issues, whether the appellant had standing to bring a 403-412 claim. The issue that we've presented to you, and I think that Your Honor correctly identified early on, is that this is an ordinance trying to be enforced by 403-412, which is not provided for under 403-412. Third, the complaint here failed to join an indispensable party, as pointed out by Your Honor, the U.S. Corps of Engineers, and as admitted by the appellant, that a cause of action doesn't exist against the Corps of Engineers. And frankly, the Supreme Court defines an indispensable party in Florida Department of Revenue versus Cummings as a party whose interest in the controversy makes it impossible to completely adjudicate the matter without affecting either that party's interest or the interest of another party to the action. Here, trying to enjoin this beach renourishment project without including the Corps of Engineers, which is the party that is designed, permitted, and is actively constructing the project, would clearly affect the Corps of Engineers, who's not a party to this case, because they have actively funded and now constructed the project. If this court were to somehow rule against appellees, how would you seek relief against the actions that the Corps has already taken in building this?
Mr. Hennessy, I'm gonna have to ask you to wrap it up, please.
Certainly. This finally wrapped in with the concept of the federal supremacy clause. We cited U.S. Postal Service versus City of Hollywood, which clearly states that a federal project is not subject to local regulations. We would therefore, for all these reasons, request the court affirm the decision of the trial court, grant appellees their appellate fees, and remand to the circuit court only for determination of a reasonable amount of those appellate fees.
Thank you, Mr. Hennessy. Mr. Safford?
Okay, thank you, Your Honor. I want to cover a couple points. And going back to your very first question, Judge LaRose, Section 54-651, the purpose of the Sarasota County Code. If you read that carefully, it says the general intent and purpose of this article is to provide for adequate regulation and control of authoring jurisdictional areas and the repair and construction of associated water-dependent structures. So I would submit the purpose is to regulate all jurisdictional areas and in addition to structures, and it's not limited specifically to structures. The second point I want to talk about is this argument now from the city that 403-412 does not apply to local laws. If you look at the plain language of 403-412 subsection 2A2, it says from violating any laws, rules, or regulations. The city wants to make the argument, well, the legislature should have put in ordinances if they wanted to include that. Well, the argument that they're making is state laws. So the contrary to that is if the legislature wanted to limit it to state laws, it would strike the word any and put state laws, rules, and regulations. In fact, they didn't do that. And even the provision of 403-412 cited by council, 9A, 403-412, it says any local government regulation, ordinance, code, rule, comprehensive plan, charter, or any other provision of law. The legislature just said right there that the 6 items it identified prior to that were provisions of law. So that would support our interpretation that the word law there applies to all laws. We also must
in 9A, the law would have to be some enactment by a local government, correct?
Correct.
Okay.
The point being made is that the legislature recognized those 1, 2, 3, 4, 5, 6 enactments by local government is a provision of law. That's what they called them. And the same would apply to 43412 subsection 2A. Again, if they wanted to limit it to the state, they could have. I would submit to you the case that we cite, Save Our Bay. I would disagree with counsel. It doesn't deal with the delegation of a state program and enforcement of state law. In that case, there was allegations of violations of both county and state laws in that case. And the court allowed that complaint to proceed. The same
Can I
way
ask you, could I, excuse me for shifting gear a little bit, but I'm curious about your take on the denial of mandamus relief.
Yes, with respect to that, Your Honor, I do not, the lower court did not ever hold that a WNCA permit was not required by the city in this case. What helped on the mandamus relief was the court was not going to order the city to apply for any permits, whether it's WNCA or under the comprehensive plan provision to apply for a permit under the county comprehensive plan provision, which is what we alleged in our initial complaint in that case. So the trial court never found WCNA applied or it didn't apply in this case. In fact, it ignored it, finding that the joint coastal permit, covered the permit exception, which for reasons I said earlier did not. And then lastly, let me get to the county here. And here the city confuses the cause of action. As I noted earlier, under 403-412, you got 2A. Under 2A, there's 2 causes of action. Subsection 1, a citizen may seek an injunction against any governmental agency charged by law with enforcing the laws. Okay, that's subsection 1. Subsection 2 provides that a citizen can maintain an action for injunctive relief against any person from violating the laws. 2 different subsections. Subsection 1, if we sued under that, we would have to sue the county and we would have to serve the notice to the county. We didn't sue the county under subsection 1. We sued under subsection 2, which only required us to provide a copy of the complaint to the city. Had we sued under subsection 1, we would have named the county and served them. But nowhere in 403-412 do you have to sue both entities, the person violating the ordinance or the government entity charged with enforcing the ordinance. So it's up to the litigant what they want to do. And specifically, 403-412 envisions such a situation because under subsection 2D, the court specifically has the ability to add the governmental agency or entity in charge of enforcing those ordinances or laws to the case. So it absolutely recognizes that they don't have to be served in the initial complaint. And that's subsection D, and it reads, in any action instituted pursuant to paragraph A, the court, in the interest of justice, may add as party defendant any government agency or authority charged with the duty of enforcing the applicable laws, rules, and regulations for the protection of air, water, and natural resources. So the statute recognizes you don't have to sue that agency. You can sue the person violating the laws, and then the court can bring them in if they want to. And if
Mr.
that's
Stafford, I'm going to ask you to please wrap it up, please.
Okay, sure. So if the court wants to bring them in, they can certainly bring them in, but our failure to name them as a party and serve them is not a basis for dismissal in this case, Your Honor. And we would just respectfully ask the court to reverse the circuit court's dismissal with prejudice in this case. Thank you, Your Honor.
Thank you. Thank you. Mr. Herron and Mr. Hennessy, if you want the last word, I'm going to give you a total of 2 minutes.
Thank you, Your Honor. With regard to a couple of issues that Mr. Stafford said, the issue that the court asked about the joint applicant and suing the city and not the Corps of Engineers. The city decided to structure this application as a joint applicant in case there wasn't federal funding, so it could decide to move forward. It could convert its status to being a co-sponsor which is specifically provided for in the statute. And the appellants have recognized and stated before the court in the record that if the city were to do and change that status, there would be no cause of action in 403-412. With regard to the issues of the seagrass and the issues that were raised by Ms. Schaefer, they were already disposed of, ruled upon by the administrative law judge. The court found that the Corps and the city met all of the environmental criteria for this project under the state statute and issued the permit. And those issues are not before this court because the appellants failed to appeal that decision within the appropriate time. I'll cede any additional argument to Mr. Hennessy.
Thank you. Mr. Hennessy, anything to add?
Excuse me. Thank you. 2 quick points. The denial of mandamus was not appealed or briefed in this case, and therefore that's not an issue here. Secondly, I would disagree with the interpretation of the notice requirement under 403-412. 2C quite specifically states that the government agency or authority charged by law with the duty of regulating or prohibiting the act being complained of. So in this case, it would be the county has the responsibility for enforcing its ordinance, and therefore notice should have been given to the county, not the city. Thank you for your time, Your Honor.
Thank you, Mr. Hennessy. Thank you all. This is a very interesting case. The court is going to take a 50